This is essentially an opportunity for us to unpack some of the things that we've been covering. You should have received, I think it was either yesterday or the day before, a scenario, which is what we're going to be having a look at. So if you wouldn't mind digging that out of your emails, I'll just put it on my screen so you can see what it looks like. Okay, so this is a situation that we're going to be discussing, and hopefully you've had a chance to read it beforehand, just to save a bit of time. But what I'll do, if you haven't had a chance, is I'll just sort of summarize it for you, and then we will discuss it. All right. So essentially, it builds on the example I gave this morning. Husband, mother and son. So you've got Mrs. Audrey Leave-Alone, who's 92 and lives with dementia. And she has been living in the family home for 35 years. Her husband passed away about 10 years ago, and her son, Jack, gave up his job and moved in to look after his mum. Jack has OCD, anxiety, and sometimes experiences depression, and is on a waiting list for counselling. Now, this is a 3-bed dormer bungalow, and you get the impression that since the husband died, both mother and son have been very reluctant to throw anything away. So as is not unfamiliar or uncommon in these sorts of scenarios, that bereavement may have triggered what follows, or at least the check that perhaps the husband was, he may have been keeping things in check, and obviously with his passing, that is no longer there. So mum considers things to be very important to her, some of which have been passed over from generation to generation. She used to be a legal secretary, thinks she still is, and so there's a lot of papers on her bed that she won't let you touch at all. And this is nothing new. Over the years, we've made numerous attempts to help address the risks arising from the hoarding, and that picture there just gives you some idea as to the extent of it. That's let's assume in the sort of living area. The Court of Protection has been previously used, so mum was accommodated in a care home under a dole's authorization, and at that stage the social worker involved a local hoarding company, Blitz It, to come in, sort out the hoard, arrange a deep clean. Mum challenged the dole's authorization, and the Court of Protection decided, Her Honour Judge Fair concluded that mum actually had capacity, despite dementia, had capacity to make decisions about residence and care, and so she went home. The judge encouraged mum and son to engage with social services, but relatively soon after mum went home, things got worse. Now, to try and, I suppose, guard against that sort of state interference in their lives, soon after she returned home after Christmas, by the time of the new year, she had created lasting powers of attorney, and she appointed her son Jack for both her property and affairs as well as her health and welfare. Okay, so and there's no challenge to that. You know, she'd just been in front of a judge who had just concluded that she had capacity to make decisions about residence and care, and so straight on the back of that, she set up her son as LPA for both her health and welfare and property and financial affairs. Also, because of the fairly heavy-handed previous experience with Blitzit, there are now massive issues in terms of engagement, because neither mum nor son, well, both of them are very reluctant to engage with us. They were clearly traumatized in many respects by what happened previously, and they live in fear of their important items being thrown away. The two of them also have a very difficult relationship, which can at times be pretty strained. She treats him like a child, and he has difficulty sort of standing up to his mum, and sometimes she can be verbally abusive. Son, Jack, does seem to be motivated, and you get the impression that he's open to the idea of being helped with the hoarding and so on, but it's her influence that's affecting that. And so out of fear, quite often she will try to sort of sabotage the process. And things are now getting extremely serious. Safeguarding referrals being raised, joint visit undertaken by a different specialist hoarding company called Making Space, as well as the fire service. And staff have described this as one of the worst properties they have visited in the last 5 years. They've described it as being similar to a sort of Victorian slum that is not fit for human habitation. And they've assessed a number of risks. So in terms of the clutter image rating scale, all of the rooms are banded between 6 and 9. And I can go through that in a bit more detail in a minute. From a fire safety and well-being point of view, this is level 3, red, which is the highest rating. And it's thought that the environment requires professional assistance to resolve the clutter and the hoard. There are also lots of maintenance issues in relation to the house. So, for example, it needs to be completely rewired. And in terms of the domestic squalor assessment, full marks, 17 out of 70. So the property is impacted by severe squalor and corrective action is said to be needed. And yeah, I've said 9 out of 9 for the clutter rating scale. So we've tried. Contractors can't get in to conduct the repairs. There are rats, there's rotting food, flies. Mum prefers to stay in her bed and uses a bedpan, which her son then empties into a bucket in her room. She's not particularly mobile. There are concerns about the personal hygiene of both. The hoarding is blocking all exit routes. The electrics are unsafe and need to be rewired. And a number of recommendations have been made. Smoke alarms, fire retardant bedding, hoarding, disposing or storing, sorting out an alternative way to cook the food, electrical rewiring, and there are concerns about the portable heaters. So, for example, Mum has a portable heater next to her bed, and we are concerned that, for example, it could overheat and the papers on her bed could catch fire and so on. So that's the kind of scenario that you're presented with, thrown in at the deep end. Typically, this would come to me and we would say, OK, well, what sort of legal framework might be available? Anyway, I've just set a few questions here, really. So what, if any, further preliminary steps do we think should be taken? How should we go about addressing the risks, legal frameworks? And if we're thinking of the Mental Capacity Act, what are the relevant decisions and information at stake? And do we need any kind of judicial involvement? If so, what type? So that's the scenario. Now, I don't know how many of us are in this room, but perhaps if we can use our electronic hand, would anyone like to share their thoughts about preliminary steps before we sort of wade in with any kind of state interference? Lindsay?
Hi Neil. I actually run Tidy Homes, Tidy Minds, which is Manchester's hoarding service, and we cover the Northwest, and we provide a one-to-one support service to physically help declutter in a trauma-informed way. So for me, we would have to look at doing a justification exercise to see what things have been done. Obviously, it would depend on tenure as well, on whether they're a social housing tenant or a owner occupier. Obviously,
So let's assume, yeah, let's assume in this case that it's mum's property. Mum owns the property. Son is obviously permitted to live there, but it's mum's property. There's no mortgage, etc.
Okay, so they're an owner occupier, so it's not as easy. Obviously, we don't have a tenancy agreement that can be enforced and things like that, but there are other powers outside of that with environmental health and obviously safeguarding and other stuff. So preliminary, I would say that you would need to, if you haven't used a service, obviously the Blitz service, which just fills me with fear, and it's something I'm absolutely against. Does not work with hoarding. It is about the stuff is just stuff. It's the cause behind it that needs to be dealt with. The stuff can quite easily be dealt with sometimes. So looking at that, has a service like ours been used or tried? We would probably be, or we are seen merely as a last resort before going to enforcement or down the judicial route, because of the service and sort of service that we offer. The problem being that the damage has already been done by the blitzing. So it's really hard to gain that confidence. And we try and, build up a relationship and build up. And sometimes we don't even do it in the house. We'll do it outside of the house for a couple of sessions, talk about anything and everything, just to get that foot in the door to, just put people at ease. And like I say, I actually work with Public Health England in Manchester and deliver the ACEs and trauma training to the regional housing providers. So our team's set up to deal with sort of the trauma-informed working executive functioning side of things, and that seems to be what makes our breakthrough and our service a little bit different. So
great. And to put it crudely, who would pay for that?
So this is the big question. There is no funding for hoarding as such. I currently have 8 cases waiting allocation to a tune of £51,000. And then they are mainly funded by adult social care, mental health, or housing providers. Because hoarding is classed as safeguarding and self-neglect under the Care Act, then we would look to ask either the person who's referred them, or if they haven't got anybody who's referred them, refer themselves, we would do a Section 42 request. And from that, we would ask that they look at the housing environment. And that should, if they can't pay for it themselves, should be enough to put through to panel for funding from the local authority. But as we know, resources are quite tight. What we have found in the last sort of 12 months, and certainly since COVID, is that social housing tenants are getting funded by the housing. So we go out and we do a free assessment and we do a full report, which actually states case law, states Disability and Equality Act law of where hoarding would sit, because it can be classed as a disability. So, and there's some case law in there of case that's gone to court and what the judge said on that, and that seems to be what sort of shoves people more towards the funding aspect. We do have people that self-fund, but not many.
Great. Well, let's assume that this family would not be willing to pay a penny because of the trauma. Okay, so that's really helpful, Lindsay. Thank you ever so much in terms of. So your sort of organisation is designed to be a bit similar to Making Space in this sort of scenario.
Yeah, we're all sort of similar. It's just that I work for a social housing provider. So I
Yeah.
work for Southway Housing Trust in Manchester, so we have different resources to what Making Space does, and a few of the other self-employed specialists, if you get
And
what I
I
mean.
should just avoid any confusion. Making Space is just a name I've invented.
Oh, right. Well, there is actually one called Making Space.
Is there? Right.
Yeah.
And I know there's a mental health charity called Making Space, but they don't deal with these sorts of cases.
No, there's an APDO member that's called Making Space.
Okay. Business model there. Right. Thanks very much, Lindsay. Right. Let me come to Tracy. I'll come to Tracy and then Fiona. Tracy? Do you want to just unmute for me, Tracy? Don't leave me hanging. Come on. No, okay, I'll come back to Tracy. Fiona, do you want to come on down? Fiona? You're all being very shy and quiet, but right. What about Kate? Can anyone find their microphone?
Can you
Kate,
hear me, Neil?
Yeah.
Hi. I've got a bit of a radical idea.
Go on.
So, Mrs. Leave Alone, she used to be a legal secretary. Could you come and work for you? And I'm partially serious about that. If that's something that's positive and meaningful in her life, that's a memory she has that she holds on to, and could be a preoccupation or a source of risk because she's keeping these documents. Is that something we could work around at a day service or community, you know, an environment that would support that role occupation and hopefully get us an inroad to working with her and building that trust? So I don't know if you're going to interview her for a post, but
I can
you've got the capability for it.
I don't think that's radical at all, actually. I think you're absolutely like, obviously there are probably different views on this, but certainly my personal view is that it's important to work with in a dementia context, it's important to work with the person in the sort of period that they're living in. So certainly she does believe she's a legal secretary. And so I would have no qualms at all about, if that does, understanding that sort of context, if there's anything that we can do that engages her, I suppose it's about engagement, isn't it? Along those lines, then a bit of, I sometimes probably bluntly refer to it as sort of therapeutic, not lying, but therapeutic context, in that age, I don't think would be untoward at all. I think that's a really good idea. In terms of day services and stuff, yeah, possibly. Whether that helps in terms of the risks, it might sort of get her out of the property if she wants to go, but obviously that we still have all these risks at stake as well. Great, thanks ever so much. Right, Tracy or Katie, have you found your...
Neil, we had to log off, so it wouldn't let us unmute. It's Fiona.
Go on then.
Yeah, so obviously I'm an adult social worker, so obviously, for me, what I'd be advising or doing myself would obviously be looking at the Care Act about our responsibility as assessment, and obviously a Section 42. But also what I'd be revisiting, yes, she's been at the court of protection at that time, but she's got dementia, which obviously is a progressive illness. So I would be, re-looking at capacity, and especially about executive functioning, where you say about, they're saying they can do X, Y, Z, but the evidence is that there isn't, that there isn't that, there is a divorce between it. Like you say, I always refer to that in my capacity assessments now. But for me, that's the route we'd be going at. And, if it was felt that she still had capacity, and the risk, obviously, like you say, she's got rats and, the fire risks, and I think you'd be using all that evidence and possibly then going for inherent jurisdiction further down the line if it was deemed that she did have capacity.
Okay, and what sort of, in terms of capacity, what sort of decisions would you say are at stake here, Fiona, that you'd be assessing their capacity to make?
Care and support needs, because within that, it isn't just about Are they able to have a shower? It's you know, I've got the appropriate equipment in place and things like that to meet that need. Obviously, you know, weaning a bedpan and then emptying it into a bucket, you know, that it's about the risks around that. That's unsanitary. Also the risk around, obviously, you know, having rats in the property, the fire risks as well. So then we'll be looking at residents, you know, if there's a hoarding, there's a falls risk, there's a fire risk. Obviously we will be trying to support the son as well as being a carer. But also just because he's got LPA doesn't mean, you know, if he's making unwise decisions, you know, then there obviously are processes we can go to the, you know, we can obviously go to court if we think that that person, you know, is making unwise decisions on their behalf. And again, it'd be all that evidence that you'd used over them few years of how, you know, it's got back to the state it is. So, you know, as this person got capacity, is it an executive functioning or is it an unwise decision?
Yeah. Okay. Thank you very much, Fiona. Tracy, and then Katie.
I'm here. Hiya, Neil. So
Hiya.
I've had a similar situation. I'm based in adults like Fiona, and obviously worked with a gentleman in his 50s. Long-standing issues with the property, to the point that we needed to remove 40 bin bags to get through the front door. So what we actually did, well, what I did with him is we done some one-to-one work together in terms of talking therapies of where the issues started basically. And what came from it is basically after the loss of his mother, he'd never left home. And the loss of his mother, he just started accumulating items and even wouldn't get rid of anything or, you know, dispose of anything. So what we did is obviously then it was referred to mental health services and had some talking therapies on a one-to-one. And what we did is we obviously involved Lindsay, you know, she was going to come and do a couple of hours a week, but he couldn't commit to that. Are you with me? And he felt quite pressured. So what we had agreed was obviously at the weekend was his best because he worked full time. So basically for a couple of hours at the weekend, we would focus on one room, or he would, and we'd do like a plan. Are you with me? Like for him, a massive achievement was he needed to put 2 items of clothing in the washing machine. So it's all about positive reinforcement when he did that. And we put like a plan in place. Obviously, you know, it's not sorted fully, but it was about working with him. And he was actually diagnosed with a hoarding disorder, you know, by mental health services. Housing were pushing to evict him, but they kind of backed off in the end because obviously, you know, I got shelter involved as well, you know, to support him. Yeah. So I think for me, it was like, you know, Lindsay said, you know, we have had the tidy ups in because for some people that does work. But some people are so overwhelmed, they can't see the wood from the trees and they want some of this stuff gone. But some people have got an emotional attachment to all of this and obviously can't let go. So we went down that route, and then obviously the reinforcement of the positivity and how well he was doing. And that went really, you know, it was long standing, don't get me wrong. And you couldn't go and see him for 5 minutes. You were there for 4 hours.
Sure.
4 hours at a time.
And obviously
it worked well.
It worked. And obviously there are degrees to all of this, aren't there? And it's great if there is that time, the availability of services. And there's some stuff in the chat as well about that sort of relational sort of building. Really. Yeah. Great. Thanks, Tracy. Let me come to Katie and then Caitlin.
But for us, just quickly, you know, it's obviously time is a factor. Are you with me? And as a rule, we haven't really got that time. But I think you've got to weigh up, you know, if this doesn't get resolved, what the issue would be. Yeah. Do you know what I mean?
Absolutely. And obviously, in the case of the Leave Alone family, one of the most pressing issues really is the fire risk. And so it's a question of balancing time against risk to life potential. Yeah. Thanks, Tracy. I'll come to Katie and then Caitlin.
Yeah, so Neil, the first thing I was going to suggest is that we have a multi-agency meeting.
Yeah.
You know, there's going to be numerous agencies involved or aware of the situation. So we need to get everyone together, don't we, and share that different risk. And I think somebody put in the chat about physical health as well. So we need the GP there. We need to understand the risk from the fire service. So I think that would be really, really important initially. I was also wondering, has she hoarded previous, is the hoarding a consequence of the dementia or the grief or both? Because I think that might then affect how we approach things as well. So if we've got people in the room that have known her for a long, long time, we might have evidence that during other incidents of grief or traumatic times that hoarding's apparent. Then I was thinking, is there anybody that she trusts more than everybody else? Because I think
only her son.
Yeah.
Yeah.
So, because I was thinking, yeah, in other cases,
But in other cases,
the
there could be-
relationship is the key, isn't it? And sometimes that's not a registered professional, because somebody will engage better with other services around them. And then I think you just take it from there, don't you? And you work through, as other people have said, around capacity assessments. And the case you mentioned earlier, that gives a lot of ideas about what you should be looking at, doesn't it, in relation to assessments of capacity? It sets it out, so that's helpful. And then you might be looking at inherent jurisdiction, or do you have to get a section 135 warrant to remove her? But those two bits are coming right down the far end when you've literally tried everything else, aren't they? And the risk is immediate. Yeah,
great. Thanks ever so much, Katie. So multi-agency meeting involving all the different sort of disciplines, sharing that risk, considering whether there's any other sort of trusted friends or family that she might be able to sort of engage with. Super. Caitlin, come on down.
I'm just building on that, really. I think the big thing is the son. So actually, he's the main carer, he's the trusted relationship. She's quite bedbound now anyway, so actually some of this we have to take into consideration is the son. So I think, starting off with a carer's assessment in his own right, maybe a carer's social worker. Does he have care and support needs? And if he does, are they related to his care, the impact of his caring role, or are they actually care and support needs in his own right? Because I'm guessing if she's 92, he's probably of a significant age as well, and may have gone through some of the other things. And I think you have touched upon the impacts of his mother, the way his mother may treat him as well. I think the key for me there was, he's most likely to be able to let somebody in the house because she's bedbound, so he's the gatekeeper. But also he has shown that he does want help and support. So again, there may be an inroad there, and we can start to look at the dynamics of that relationship. Because I know the other groups talking about it, but I do think we need to look at that think family model in these kind of situations and the impact that both of them may have on the other, and actually who is the biggest hoarder, who has actually got the issue with that, because we're almost assuming it's her, but he's been living with her the whole time that we've known that the hoarding has been going on. So I just think, and kind of separating them as well, but seeing the impact of each other is really, really key.
Absolutely. Great. Thanks, Caitlin. And crucially, this is very much more about the son, in fact, than about the mum, for the reasons you've given, really. Like she's not been out of her room for years. So in terms of the hoarding around the property, that's all because of the son. So he really is the key figure in all of this, and so considering both of them is going to be absolutely critical. Super. Thanks, Caitlin. Rory, is it Rory?
Hello.
Hi there.
It is, yeah. Can you hear me?
Yeah,
good, yeah. Obviously very case. I'm a CSP student, district nurse student in fact. So yeah, if you were to, for a district nurse to go, you would need a nursing need. So she clearly has some, just off the thing with her age, problem mobility, frailty. If she's bedbound, she's at risk of pressure, getting pressure damage. That would mean that she would need equipment. So you'd have all them problems of getting that equipment in a place which is already, is clearly obstructed, probably pathways to places, bathrooms, sink, etc. So that would raise all them issues. So then, because you've met, with this situation and the self-neglect part of that. First of all, you know, you would try to have a rapport with and try and suggest where they're at risk, why they're at risk, explain them, you know, risk needs, what they were, what the potentials are. And, you know, hopefully if you could work with them in that way, might take a few visits, then you know, you may start to get somewhere. But clearly if you've got this big barrier, it can't go on for a long time. And, you know, from a district nursing point of view, you'd have to inform GP, you'd probably inform social services, but you would have to get consent for these things. So the capacity being the big issue, because, you know, it's always consent to care. We have to get consent to make referrals to anyone. So that would be a big issue. But I mean, if we did think capacity were an issue, that would be for us a referral to GP or social worker. And, you know, you could offer someone a social worker, would they mind a referral? Would that be okay?
Yeah.
So you know, you could slowly get a kind approach. Because at the end of the day, we are here to help people and avoid what could in the end be a tragedy. I mean, like the fire risk is like proper frightening, isn't it? And then you've got the health things of rats and mice and flies, and, you know, it's not a clean environment. It's not good for your health neither, and all them issues. Yeah. So I mean, some of the things we have talked about today have been very interesting and quite, you know, maybe think slightly different in the way of your practice. You know, so it's been really good. Yeah.
Okay, great. Thanks, Rory. And
problem.
just before I come to, well, Brendan, do you want to come in?
Yeah, thanks, Neil. I was just going to, when it's okay with you, just summarise a couple of the comments in the chat.
Yeah, go for it.
Yeah, just a few things that I've seen pop up that I just thought I'd summarise, given time constraints, etc. Just people commenting on the sort of advocacy, formal advocacy is an approach, both sort of in if appropriate, or Care Act advocate, some kind of formal representation of that person's views. The sort of longer term, the therapeutic type approach and the building of trust and engagement over time has been commented on by quite a few people. The sort of sentimentality, I think, of a lot of the things that people hoard, etc. But then again, somebody's commented about addressing the immediate risks as well, so addressing those as urgent, and then looking at longer term goals in a sort of staged way. So that's just a brief overview of some of the stuff that's come up in the chat.
Great, thanks very much. And what time are we finishing this session, Brendan? Is it half past?
Yeah, it's half past.
Half past. Okay, great. So thanks for that. And obviously, as a lawyer, I'm going to be focused on the legal side of things, but certainly from my point of view, I would be saying, you know, great ideas, and obviously engagement and working with is the key, and usually leads to better outcomes. For those other measures where we're talking about, you know, addressing the risk of X, obviously the legal question is, well, what legal framework do you have in mind? Because, for example, you might be thinking, well, you know, we need to deal with the fire risks, but then what's the legal framework for the fire service to go in if, for example, the son won't open the door? Katie mentioned Section 135 of the Mental Health Act, but that's certainly available, but would only tend to be used in real kind of emergency scenarios. So I thought it might be helpful just to emphasize really what potentially is out there, because I think in these sorts of cases, there is a shed load of law, right, from all sorts of areas, which I suppose very much reflects the multi-agency dimension to these sorts of scenarios. So in this slide, these are just a few, right? But essentially here you've got sort of 14 different bits of law that might potentially be relevant. Obviously, human rights runs through this, both the right to autonomy, but also the right to dignity, amongst other things. And of course, if, for example, we were looking to remove someone from the home to keep them somewhere else, whatever framework it might be that we use for that, then there could be issues of deprivation of liberty as well. We talked about the Care Act. There's also, and again, I think it was it Lindsay that mentioned this, it's worth bearing in mind that a lot of the relevant law here has nothing to do with capacity. So when it comes to things like rats and mice, or, you know, public health issues, then you've got other laws that are not necessarily dependent on capacity. I had a case recently, for example, number 13, up top left-hand corner, involving hoarding, which amounted to a statutory nuisance. And so under the Environmental Protection Act, the occupier was served with an abatement notice. Again, has nothing to do with capacity. It's an abatement notice requiring them to take steps to rectify the nuisance, essentially deal with the hoarding, failing which there is then powers to then intervene. If animals are at risk, you know, there's the Animal Welfare Act, children, it's about gaining access. So there's a lot of, and as I said, there's lots more as well. I'm sure Michael will talk about other options as well, but there's a lot of tools, if you like, legal tools in the kit that could potentially be relevant. And that's why I think that multi-dimensional, multi-agency approach is particularly important. I'm just going to focus on 7 and 8 out of those. Okay, so the potential use of the Mental Capacity Act, and when we might be looking at the inherent jurisdiction. Okay, so we've talked about section 42 of the Care Act, and what I've highlighted there is that there may come a point where an adult is no longer able to essentially protect themselves by controlling their own behavior without external support. And I'm quite interested in, well, what is the role there of the Mental Capacity Act? Because I think in some of these cases, we can address issues in a less restrictive way by intervening earlier in using the Mental Capacity Act. And there's various bits and bats out there to illustrate this, but I've just picked out an ombudsman's report here that emphasises that there's a balance to be struck between the individual's autonomy and dignity. I'm not entirely convinced we've struck that balance. I think often in the sort of SARS reports and so on, I think sometimes people have sort of over relied on autonomy at the expense of dignity, and I think striking that balance is key, because from a Care Act well-being perspective, you know, there's a number of aspects of well-being that are particularly relevant in cases like the leave alones. So personal dignity, protection from abuse and neglect, suitability of living accommodation. We've also had quite an interesting case involving Mr. Myers in Southend-on-Sea. I'm going to come back to him. I've only got 5 minutes, but I'll come back to him. But essentially, again, it's a hoarding case. No, it's not hoarding. It's a self-neglect case, really severe self-neglect case involving father and son, where the treatment of the father has not merely been neglectful, but abusive and corrosive of his dignity. So again, notice the role of dignity in all these sorts of cases. And that's the key bits of the Environmental Protection Act around statutory nuisances that I was talking about earlier on. If you're not familiar with hoarding disorder, I've also put some slides together that set out what it is, because this has changed, I would say, in the last 9 years or so. It used to be seen as part of OCD. Now it's recognised as a condition in and of itself. Psychologists, psychiatrists tend to use either the DSM-5, the Diagnostic and Statistical Manual version 5, or the ICD-10. But in both of those sort of statistical manuals, those research manuals, you will see a definition of hoarding disorder. So by all means, have a look at that in your own time. This is what the ICD-11 says. So it's characterized by accumulating possessions, resulting in living spaces becoming cluttered to the point where their use or safety is compromised. And then it goes on to describe that in more detail. So hoarding disorder, and I think you probably would need some kind of health input if we were not clear about whether or not the person had hoarding disorder. I don't know what your views are, but I think you know, I think this is one of those situations where I would want health involvement to try and determine whether someone sort of reaches the criteria, if you like, of hoarding disorder. But those are the 4 sort of elements of it. Persistent difficulty discarding or parting with possessions, regardless of value, amassing items that compromise the use and safety of living spaces, which then causes significant distress or impairment in various ways, which is not attributable or better explained by a different condition. Okay, so I think we'd want health involved in that regard. And Katie, you know, mentioned the role of the GP in terms of physical health, but also we might want mental health involved in that sort of multi-agency approach. I mentioned clutter scales. You've probably seen these already, but this is what they look like. And we also use sometimes the Saving Inventory Revised questionnaire, which is a sort of self-reporting measure that evaluates people's beliefs and emotional attachment to possessions, because, you know, again, that's a really important thing that's been emphasized in this session, the idea that because normally from my experience, you've got like rotting food and similar sort of rotting things on the other hand, on the one hand, but then you've got other items and belongings, and often that's where there's a very strong emotional attachment, which obviously then causes anxiety if we are to store them or potentially dispose. So those are all the clutter image rating scales. 4 and above is a clinical indication, all right, and obviously in this case it's rated as between 6 and 9, so that gives you a flavor of what the kitchen might look like, what the bedroom might look like. You know, when people talk about lifestyle choice, there is no way that 6, 7, 8 or 9 is a lifestyle choice. Do you know what I mean? And then this is the rating scale for living rooms. No nice guidelines in terms of hoarding disorder. You won't see any nice guidelines on that. Blitzing doesn't remedy the cause, as Lindsay said. It's sometimes the worst thing that can possibly be done, because typically it will then cause significant distress, lead to more mistrust, and the person is perhaps likely to hoard more in order to replace what was taken. If the person is willing to engage, then there might be options. Potentially medication, psychology, CBT, skills training, etc. Whereas if someone has a more chronic and progressive condition, then usually we're focusing very much on safety and risk mitigation through care and support planning, and trusting relationships are obviously absolutely pivotal. So what might the MCA have to offer? Well, I think if we carefully think about the decision and the information that's relevant, and obviously if the person is unable to make those decisions because of a mental impairment, then that does open the way for a best interest decision to be made. Sometimes we talked about advocacy, whether that's Care Act advocacy or some other form of advocacy, and usually that's a brilliant idea, really, really important. Sometimes there is legal advocacy, so the person might be able to get a lawyer involved, but that's usually dependent on funding. Certainly in the Leave Alone case, mum didn't qualify for legal aid, whereas the son did, because that's entirely governed by financial means. And obviously, if there is evidence of incapacity relating to any of these sorts of decisions, then typically, if we are really struggling to, engage with the family to address these sorts of issues, don't forget, of course, there is then the Court of Protection available. And the Court of Protection, judges in the Court of Protection have all sorts of powers. So, for example, we might well struggle to gain lawful access, but if there's evidence of incapacity, then the judge can give us access. And similarly, again, if we're in the realms of best interest decision making, the Court of Protection judge can make those sorts of best interest decisions, which then give us the legal authority to step in. And so we've been through the AC and GC case earlier on. I'll put a link to that judgment in the chat if you want to read about it in more detail. But essentially, the outcome of this case was that the son gave up his LPAs. Okay, so he gave up his lasting powers of attorney, disclaimed them, as it's called, which then meant the judge was free to make all the sorts of best interest decisions. And so what the judge did was to, first of all, appoint a financial deputy for the mother. And so now it's the financial deputy that has the legal authority to manage finances and deal with mum's property, including what's inside the property. So now the deputy is working with the likes of this fictional sort of Making Space or other organisations. It's the deputy that has the legal power to remove items and belongings from the property and either dispose or put into storage. So a financial deputy was incredibly important in this case. And the court has also essentially required the son to abide by a number of conditions. Again, you'll see this in the judgment, but for example, he's not allowed to smoke inside the property because of the fire risk, etc., etc. And we're currently in the process of rewiring the entire thing. And then just very conscious of the time, very quickly, the inherent jurisdiction. It's a bit of a Wild West. You've got the facts of the Myers case, 97-year-old. The key thing about Mr. Myers is that he has no mental impairment at all. Okay, so this case is quite different to the one we've just looked at because the Mental Capacity Act is simply not available here. He has no mental impairment. He has diabetes, osteoarthritis, and is blind in both eyes. And essentially, it's a very sort of severe squalor case. Difficult relationship between father and son. Father was entirely capable and had capacity to make decisions about where he resided and with whom, but the son was influencing the father in a very malign way. And so in essence, the High Court judge, Mr. Justice Hayden, decided to use this inherent power that High Court judges have to intervene. And what that meant was that the father, who was in a care home at this stage, could not go back home unless the son moved out. Obviously, that's a decision that only High Court judges can take in these sorts of cases. We can't do that. But essentially, that was the sort of decision that was made. Your dad's not coming home unless you move out. And from what I understand, that very much changed the dynamics. And sure enough, the father was then able to return home. So that's a very sort of quick run through. Mindful of the time, I'll just very quickly put the link to the judgment in the chat. Right, Brendan, back to you.